Former National Assembly Speaker Nosiviwe Mapisa-Nqakula's corruption matter has been transferred to the High Court. She's accused of accepting bribes from contractors in exchange for tenders during her tenure as Defence Minister. The SANDF confirmed that Mapisa-Nqakula's lawyers had applied for it to fund the legal cost of her trial, but it has been declined. Nqakula is expected to make another court appearance on the 9th of July. For more on this, let's now speak to the Solicitor General of the country, Fhedzisani Pandelani, who's joining us this morning. SG, good morning. Thank you so much for making time for us. I just quickly want some clarity on this aspect. So, initially, when the former National Assembly Speaker made the application, it was made directly to the Department of Defence. We understand that there was an agreement, and then later on the Minister then intervened and the application has been declined. When it comes to matters relating to a former public servant, I don't know if a minister would be characterized as a former public servant, but she was working in public office. Which office would she then have to go to in case there is a legal matter, before we deal with the nitty-gritties?
Thank you very much. Good morning to you, Aldrin, and your viewers. And thanks for having me. Look, in the space in which we operate, there are policies, more particularly since the creation of the Office of the Solicitor General. There have been about 7 instruments that have been created. Now, one of the critical pillars that has been created is what we call state legal representation policy. The state legal representation policy is intended to make the state to operate optimally and with agility. The baseline budget of any government entity or department is the one that is responsible. But in terms of the policy, the initial request is sent to or made to the Office of State Attorney having jurisdiction. Okay.
But in this particular case, you went straight to the Department of Defence. Are you saying that that was the wrong, the wrong process followed there?
No, that's not the wrong process. That is the initial process. So what you would do if you are attached to a department or an entity, you will start there, and then that entity will then make the necessary request and remit the documents to the Office of State Attorney that is seized with having to make a decision.
Okay, so the application then ends up on the office of the Solicitor General or the State Attorney. Why was it declined?
It's a process flow. So in terms of the policy, the decision maker in relation to the initial request is the head of Office of State Attorney. The Solicitor General is the appeals authority in relation to decisions that are made by the Office of State Attorney. With particular reference to this matter, I might not be able to have the necessary optics because it has not been delivered or served to me. There is no appeal that has been forwarded to me. All that I know is what I can read on the papers, that the request has been made to the Office of State Attorney and that the State Attorney's office has declined the application. But as I sit right now, I've not received any appeal in relation to that decision.
Yeah, would there be a deadline after the State Attorney has declined before an appeal can be made?
Yeah, subject to correction, I think it's about 60 days, if I'm not mistaken, from the date upon which a decision has been made, that a matter could be remitted to the Solicitor General for a decision to relook the decision that has been made by the head of office. But as I'm indicating, I've not actually received anything formally or informally in relation to this particular matter.
Yeah. And when it comes to an appeal, what is it that the Solicitor General will then be looking at? And I'm not asking specifically on this case because, as you say, that there is no appeal as yet, but just speaking in general, what are some of the aspects that the Solicitor General need to satisfy himself with before making that final decision?
The process is actually intended to be, transparent and fair to all parties concerned. There could be additional points that the head of Office of State Attorney might not have considered or alternatively, there could be additional facts that needs to be brought to the attention of the Office of the Solicitor General. So there are quite a conspectus of issues that are looked into because, you know, some of the decisions that we make as creatures of statute are reviewable in nature. So we look at quite a number of things, and more particularly, we look at whether the head of Office of State Attorney had overlooked any aspect that is contained in the policy in relation to state legal funding.
Okay, so the introduction of the state legal policy or state representation in terms of the legal policy, what is it then that would be looked into to look into whether or not the state is liable in terms of the legal fees of a person, whether it is a former Minister of Defense or whether it is a person who is employed under the Public Service Administration Act?
No, thank you very much. That's a good question, Aldrin. Primarily, when you are performing duties on behalf of an employer, there probably would be one or other thing that would go wrong. That is falling within the narrow category of what we call within the course and scope of the employment or furthering the business interests of the employer. In this instance, we're talking about the state. There are categories of matters which fall within what we would ordinarily say is within the course and scope of employment. However, there are exclusions, Aldrin, and exclusions would in fact include issues such as criminality, malfeasance, corruption, and a whole lot of other aspects. More particularly, the policy seeks to do away with a situation where you are employed by the state, you are found with your hand in the till, and then thereafter, when you are arrested, you then turn around and say, well, anyway, I did this within the course and scope of my employment, and therefore, because now I'm arrested, I need now the state to come on board to represent me. So we had to distill the abuse of state resources in relation to quite a number of categories of matters. And so you would find that since the introduction of the policy, quite a number of issues that fall within what we call colloquially malfeasances are excluded from state legal funding.
Yeah. What happens then if the accused person, whether it is the minister or an individual employed under the Public Service Administration Act, is then found not guilty in that particular case, even though they argued that this was an allegation that was made while doing their work as part of their employment? Are they able to come back to the state and say that, well, you need to now refund me all of this money that I've spent on legal fees?
Now, each case is dealt with on its own merits. You know, there are those cases that we call borderline cases. But as you would appreciate, Aldrin, even under circumstances where the state determines that it is warranted that we offer state legal funding, you as the recipient of the benefits are still required to sign what we call an undertaking to repay the state, meaning even under circumstances where you fell within the category where we believed you needed to be represented, if at the end of that matter something goes wrong, we might actually be calling upon you to refund the state each and every cent that has been spent in relation to that particular matter. And we might actually be going for your pension if you don't have any other resources. So it's a touch and go kind of a situation. In borderline cases, we usually err on the side of caution. However, should it happen that somebody, who alleges that the allegations against them are ill-founded and so on and so forth, they are still, in fact, entitled to the other remedies that are available in law. If the state were to prosecute you maliciously, you still have the opportunity as a citizen to then go against the state to be redeemed from the false accusations that have been made against you. So I've not up to date seen anyone coming to us saying, look, I've had to spend so much in legal representation on my own account, owing to the fact that you have not actually covered me and therefore I need a refund. So each case will have to be dealt with on its own merits.
Okay. Finally, SG, and of course this policy stems from the Supreme Court of Appeals case against former President Jacob Zuma and the legal fees that were paid in his corruption cases as well. There was a statement that was issued before by the Solicitor General that there is money still owed by the former president. How far has he been able to pay what is owed to the state?
No, the matter, Aldrin, is playing out in court as we speak. And, you know, without actually having to hide behind the word, it's sub judice. I think all parties are now focused on the court proceedings. So I would not be able to say to you as we speak right now how much has been paid, because that is a matter that is still yet to be fully ventilated before the courts. And I will reserve my comments in relation to any quantum that has been paid. But if you were to ask me differently, have we received any cent in relation to what the court ordered, the answer is no.
Okay, thank you so much. That is the Solicitor General of the country, Fhedzisani Pandelani. Thank you so much for making time for us.